Most seniors think gun rights only get weaker with age. The truth is, some of your biggest protections are the exact ones almost nobody talks about until something goes wrong. And if you miss these, you could give up a right you never had to lose in the first place. Pause. Quick question before we continue. Are you subscribed? Because this channel is built for people who want the truth before a bad stop, a bad form, or a bad assumption turns into a legal nightmare. If you care about staying informed without all the political noise, hit that subscribe button right now. Let's get into it. The first forgotten senior gun right is simple, but it shocks people every time. Federal law does not set a maximum age for owning a gun. Let me say that again, because this is where so many older Americans get misled. There are federal minimum age rules, but there is no federal rule that says you hit a certain birthday and suddenly age alone strips your rights away. That matters more than you think. I talk to people all the time who say, I'm over 70 now, maybe I shouldn't renew. Or, I'm 82, maybe they can deny me just because of my age. Most people think getting older automatically puts your rights on a countdown clock. But the truth is, age by itself is not the disqualifier. What matters is whether you are otherwise prohibited under the law. Here's why that matters in real life. Imagine you walk into a gun store at 68, 74, or 89. You fill out the form, you pass the background check, you are a lawful buyer. Your age alone is not the problem. Now, could a seller notice obvious impairment and stop the sale? Sure. Could state law add rules? In some places, yes. But that is very different from saying seniors lose their gun rights because they are seniors. Those are not the same thing. And here's the part nobody talks about. A lot of older gun owners give up rights voluntarily because they hear bad information from neighbors, family members, or even people who sound professional. They get told, once you agree on certain benefits, forget it. Or, once you're old enough to need help, the government takes your guns. That kind of blanket statement is just not true. Second, getting Social Security benefits does not automatically kill your gun rights. This one caused huge confusion for years. People heard that if you had a representative payee, meaning someone helped manage your checks, your name would go into the background check system, and that would be the end of it. But here's what most people get wrong. A Social Security rule from 2016 that would have reported certain beneficiaries to the background check system was nullified by Congress in 2017. That means being older, being retired, being on Social Security, or even having help handling your benefit payments does not automatically make you a prohibited person under federal law. And that is a big deal, because a lot of seniors and their families still believe the old rumor. Now, don't twist what I'm saying. I'm not telling you that every benefit situation is harmless. I'm telling you that the blanket claim is false. You get Social Security help, so you lose your rights. No, that is not the rule. Third, if you are a veteran, this next part is huge. For years, many veterans feared that needing a VA fiduciary meant they were basically one form away from losing Second Amendment rights. In plain English, a fiduciary is someone appointed to help manage benefits for a veteran who cannot handle those funds alone. And for a long time, people treated that like automatic proof that gun rights were gone. But here is where it gets interesting. The VA announced a change ending the old practice of sending those names to the background check system just because a veteran had a fiduciary. Think about how important that is for older veterans. A lot of them are not criminals. They are not violent. They are not a threat. They may just need help with paperwork, bills, or benefit management. That is very different from saying they should automatically lose a constitutional right. But wait, there's something even more important. Just because one scary rumor is false does not mean you can relax and ignore everything. You still need to know what actually can trigger a prohibition. And that brings me to the fourth forgotten right, which is really a warning wrapped inside a protection. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it, because one short sentence said the wrong way can create problems you never saw coming. Fourth, a diagnosis alone is not the same thing as a federal gun ban. This is the part that shocked me when I first dug into it years ago. People hear words like dementia, depression, PTSD, anxiety, or cognitive decline, and they assume the legal answer is automatic. It's not that simple. Under federal law, the key issue is usually not just a medical label. The key issue is whether there has been a formal adjudication by a court, board, commission, or other lawful authority, or a formal commitment to a mental institution. In other words, there has to be a real legal event, not just gossip, not just a family argument, and not just a doctor writing something in a chart. Here's a hypothetical example to explain this. Let's say your uncle is 76 and gets treated for depression after losing his spouse. He sees a doctor, he takes medication, he even talks to a counselor every week. A lot of people would hear that and panic, but treatment alone is not the same as a federal firearms prohibition. Now let me show you the other side, because this is where people get burned. Suppose a court or lawful authority makes a formal finding that a person cannot manage his own affairs, or the person is involuntarily committed to a mental institution. Now the legal picture can change fast. That is why I always tell people to stop using street lawyer logic. The details matter. And here's the part nobody wants to say out loud. Some families try to help an older parent by pushing papers they do not understand. Guardianship petitions, competency findings, emergency orders. Then later, the same family is stunned when gun rights become part of the fallout. So the forgotten right here is this. You do not automatically lose your rights because of a diagnosis, counseling, or voluntary observation. But you absolutely must understand when a formal legal process crosses the line. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Fifth, seniors often forget they may lawfully possess firearms in national parks if they are otherwise lawful under federal, state, and local law. Why does this matter? Because retired Americans travel a lot. RV trips, state park loops, national park vacations, grandkids in the back seat, cooler in the trunk, and a firearm packed away because the trip crosses half the country. Most people think national parks are a total no-go zone for firearms. But the truth is more specific. In general, if you can legally possess under the law of the state where that part of the park is located, you can possess there. But here's the crazy part. Federal facilities inside the park are different. Visitor centers, ranger stations, government offices, fee buildings, those places can be off limits. And using or discharging the gun inside the park is a whole separate issue. So imagine you are driving through a national park on a retirement road trip. You may be legal on the road and illegal the moment you step into the wrong federal building with the gun. That is the kind of trap older travelers need to know about. The right exists, but so do the limits. Sixth, and this one is massive for snowbirds, seniors still have a federal protection for interstate transportation of firearms under very specific conditions. This comes up all the time with people who split the year between two states or drive from one lawful state to another through places with very strict rules. Here's the plain English version. Federal law gives protection when you're traveling from a place where you may lawfully possess and carry the firearm to another place where you may lawfully possess and carry it, and during transport the gun is unloaded and not readily accessible. If the vehicle has no separate trunk, it should be in a locked container, not the glove box or center console. Have you ever wondered why one stop on a long trip feels easy, but another feels risky? This is why. People hear federal protection and think it means a magic shield. It is not. It is narrow. The conditions matter. Your start point matters. Your destination matters. How the gun is stored matters. And if you make a casual detour or stay somewhere that changes the facts, things can get messy fast. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners who want clear, plain English legal updates before the next rule change, court fight, or agency memo catches them off guard. Click subscribe right now. Seventh, and this is one families discover way too late, there is an important exception for lawful inheritance. A lot of seniors believe that when they die, their firearms automatically become a legal mess for their children, especially if the child lives in another state. But federal law has a specific exception for a lawful bequest, meaning a transfer through a will, or intestate succession, meaning inheritance under state law when there is no will. Why does that matter? Because it means inheritance is not treated the same way as some random private sale across state lines. That is huge for older gun owners doing estate planning. Here's a hypothetical example. A grandmother in Arizona leaves a revolver to her adult daughter who lives in Oklahoma. The family assumes, we can't touch this. It's across state lines. This has to be illegal. But inheritance has its own rules. That does not mean every transfer is simple. It does not mean state law disappears. And it definitely does not mean special items are all treated the same. But it does mean older gun owners have more planning options than most families realize. And here's what most people get wrong. They wait too long. They think estate planning only matters for houses, bank accounts, and life insurance. Meanwhile, the firearms stay locked in a closet. Nobody knows what the owner wanted. And after death, the family is left confused, emotional, and scared to do the wrong thing. That confusion leads to bad choices. So let me tie these 7 rights together for you. First, age alone is not a federal disqualifier. Second, Social Security status does not automatically erase your rights. Third, VA fiduciary status is not the automatic gun rights death sentence many older veterans were told it was. Fourth, a diagnosis alone is not the same as a formal legal prohibition, though court findings and involuntary commitments can change everything. Fifth, lawful possession in national parks may be allowed, but federal buildings inside those parks are a different story. Sixth, interstate travel protections exist, but only if you follow the storage and route rules carefully. Seventh, lawful inheritance is a real exception. And smart seniors should plan for it now, not later. But here's the biggest lesson of all. Your rights do not usually disappear in one dramatic movie moment. They disappear through confusion, through family pressure, through bad assumptions, through one signed paper nobody explained to you, through one road trip where you thought close enough was good enough. This information can change fast as states rewrite rules and agencies change policies. Subscribe now, because in the next video, I'm going to break down exactly what older gun owners and their families should review this year before a move, a medical event, or an estate decision creates a problem that could have been avoided. Here's the key takeaway. If you are a senior gun owner or you love one, do not assume the law is against you just because you are older. A lot of the danger comes from not knowing where your rights still exist and where the real legal lines actually are. Pause. If this helped you even a little, subscribe and stay with this channel. I make these videos for people who want calm, honest, no-hype information they can actually use to protect themselves and their families. And one last simple disclaimer. Laws vary by state, facts matter, and this video is not personal legal advice. Before you act on any of this, talk to a qualified attorney in your state who can look at your exact situation.